You've heard of the butterfly effect, right? Supposedly, a butterfly flapping its wings in Manhattan can set off a tidal wave in Japan. Perhaps an aluminum butterfly is to blame for United States versus Aluminum Company of America. That's the company better known as Alcoa. Among other things, they make aluminum foil wrap. Don't let this case foil you. In 1937, the government sued Alcoa and a Canadian company called Aluminum Limited, or more simply Limited, for violating the Sherman Antitrust Act of 1890. Alcoa controlled a whopping 91% of the market for virgin ingots, raw aluminum made from scratch rather than from recycled metal. Federal antitrust regulators attributed this dominance to numerous instances of monopolistic behavior on Alcoa's part. Regarding Limited, Alcoa spun off Limited so it could sell its foreign assets to the new company. There were no legal ties between Alcoa and Limited, but Alcoa's president and a few other shareholders controlled both companies, and both companies occasionally did business with each other on unusually generous terms. The most damning evidence against Limited arose from its dealings with the Alliance, a cartel of European aluminum producers. Alcoa's president was largely responsible for the Alliance's existence, and he influenced Limited's decision to join the cartel. But there was no evidence that either Davis or Alcoa was directly involved in the cartel's affairs. In 1931 and again in 1936, Alliance members agreed to fix aluminum prices by capping production. A specific goal of the 1936 agreement was to limit the amount of European and Canadian aluminum available for export to the United States. Theoretically, this would benefit Alcoa by reducing competition from foreign aluminum, but it's hard to tell if the agreement ever really had that effect. After a 5-year trial and 40,000 pages of testimony, the district court dismissed the case. The government appealed. So many Supreme Court justices recused themselves that the court couldn't assemble a quorum to hear the case. The remaining justices referred the government's appeal to the Second Circuit.